Did it swap my view? Can you guys see okay? Or did I need to switch?
Yeah.
It's no, it's good.
Yeah.
Okay.
Yeah.
It looks like we got a few more people.
All right. Here we go. Go ahead and let them in. Wow. All right. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of inherited property for clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I work as the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, Lone Star Legal Aid, Houston Volunteer Lawyers, the Harris County Attorney's Office, and today presenting on behalf of our partners with the Texas Legal Services Center, we have Ms. Lisa Nelson. We also have in partnership that's included today, Ms. Mabel Menifee with the Harris Central Appraisal District, along with Ms. Vicki Fatsura with the Harris County Tax Office. Um, and then we have Donna Pensick is also here on behalf of our partner with HCAD, who's going to be monitoring the chat and also including her expertise on the presentation as well. But oh, and the Earl Carr Institute. I forgot about the Earl Carr Institute. But together we make up a month of service, and a month of service is all 9 of our organizations coming together in a collective effort to pool a lot of our initiatives and our programs and our workshops and our services so that we can provide as much information out to the community as we possibly can to reach a broader audience and to create a larger impact in essence. So we decided to collaborate several years ago, and we started out doing all of our sessions in person. But of course, you know, we've had to adjust to the virtual platform due to the pandemic. But we're slowly getting back out there in a hybrid format so that we're online on Zoom for all of you for your convenience, as well as for those folks who that necessarily they receive the information better to be in person than versus being in virtual settings. So, but be on the lookout for us to be out in your area somewhere in in the fall, in August or September sometime, with more of our in-person presentation. So, with that being said, this particular session for today is kind of like the part 2. Last week's session was about the wills and estate planning. We went over what happened to prepare for the event of incapacity or someone's passing. This time we're here to talk about what happens after someone passes. What does the probate process actually look like? What does probate actually mean when you pass with or without a will? What does title or clear title mean for your particular property? What that looks like if someone passes with deferred property taxes, what their payment options are, what that bill looks like, the time frame that they need to pay. So we're going to cover all of that information for you today. And also, Ms. Lisa is going to be telling you about how to actually clear title. So if you've inherited some property from some of your relatives, or there are multiple heirs on a property that has not been switched over or properly changed ownership, then she's going to go over and tell you how to do that. This is your opportunity to ask questions of the experts that we have online today. However, we're not going to get into personal detailed situation for each individuals, as we are on a public platform. We are record this session, so we do want to try to protect your privacy as best as we possibly can. In addition to that, we want to everybody to know that this is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our individual partners if you have some real specific detail questions about your particular situation. So this would not be the setting to kind of dig into my mom passed on this day, and you know we have this many heirs, and I live at, and the property is located at. Please don't give us all that information on this platform. Again, we want to try to protect your privacy as best as we possibly can. So with that being said, if you are joining us on Zoom, please feel free to type your question into the comment section. Or in the chat, or unmute yourself at the end of the presentation, and you can speak freely to ask the questions directly of the presenters, or if that's what you're more comfortable with, just type it in there or raise your hand, with whichever's best for you. If you are joining us from our social media sites or YouTube, type your question in the comment section, and I'll be happy to read that question aloud at the end of the presentation as well to make sure that that question gets addressed to everyone. So, without further ado, there's a lot that we're going to cover again today. So we want to welcome you and thank you all for joining us and being here. So we're going to go ahead and have our partners to introduce themselves, and then we'll move right on into the presentation. So, Ms. Vicky, why don't we have you go first, and then Ms. Mabel, and then Ms. Lisa, you introduce, and then you can move right on into your presentation. So, oops, wrong thing. Okay, go ahead,
Hi,
Ms. Vicky.
everyone. Yes. Hi, everyone. Hello. Good afternoon. I'm Vicky Fatsura, and I am with the Harris County Tax Office of Miss Annette Ramirez. Thank you.
All right,
All right, good
Ms.
afternoon.
Mabel.
Sure. Good afternoon, everyone. My name is Mabel Menifee. I'm with the Harris Central Appraisal District, and I'm happy to be on today to participate in this discussion and provide information about the appraisal district's role in this process. So looking forward to speaking with you later.
Lisa.
Hi, everybody. Thank you so much for joining us this afternoon. My name is Lisa Nelson. I am a staff attorney with Texas Legal Services Center, and we'll go ahead and get started. Is my screen sharing correctly?
It's coming up. It hasn't loaded yet. Yes, ma'am,
Okay.
you're good.
Okay, great. I'm here today to talk about clearing title and other probate concerns. As Ms. Nia said, this is a part 2 for the estate plans class that hopefully you have attended. I'm going to give a brief overview of the probate process and then talk about how to handle any property you might inherit. After I finish, I always want to end with explaining how to transfer property to your loved ones in order to prevent any problems in the future. And then I'll pass it over to my Harris Central Appraisal District and the Harris County Property Tax to talk about the property tax issues having to do with inherited property. I'm with Texas Legal Services Center. We've been around since 1981, and we're a statewide organization that serves underserved people across the state. We have about 10 practice areas, so we touch almost every aspect of civil law impacting low-income Texans. And we're here to ensure equal justice for all Texans by educating, empowering, and representing vulnerable people while reshaping the greater legal system that impacts us all. I'll also put my contact information in the chat. You're welcome to email me with questions. There's a lot of new vocabulary to learn when you're dealing with someone passing and going through the probate system. So I'm going to go over that briefly. A decedent is what you call the person who passed. If they passed with a will, they're considered testate. If someone passes without a valid will, that means they're intestate. And what I mean by valid will is a will that's compliant with Texas laws. Just because someone has a will doesn't mean that the will is valid according to Texas laws. Testator, like testate, has to do with the will. It's what we call someone when they sign the will. And a will is a legal document that states how the testator's property is distributed at death. Estate is your stuff. It's your property, both real and personal, that you owned at the time of your passing. And probate is the general term for the court process. Whether someone has a will or not, they go through the probate process. However, if they did not have a will, it's called administration. And I try to use the term personal representative because it includes people who have wills and do not have wills. But if someone passed with a will, the person who is responsible for their affairs is the executor. And if they did not have a will, that person is known as an administrator. An heir or a beneficiary is the person who either inherits through a will or by law. A lot of people think that a power of attorney is just as good as a will, but powers of attorney are only valid when someone is living. Once they pass, power of attorney is void. A lot of people think, well, I don't need a will because I'm married and Texas is a community property state. It's not that straightforward. If there is a surviving spouse, they have a right to live in a house in the deceased person's home for their lifetime. That's known as a life estate. They can remain in the home until they pass. However, they are responsible for any loan payments, property taxes, and maintenance. If the person had a will, you have to go through the probate process. A lot of people think that if there's a will, they automatically inherit. I was named in the will to inherit this house, so it's my house. It's not that simple. You do have to go through the probate court. When you appoint someone to manage an estate, they have to be over the age of 18, and it is best if they live within Texas. There are some loopholes if they don't, but it's highly recommended that the executor or administrator lives in Texas. Children under the age of 18 cannot legally inherit. They are unable to inherit until they turn 18. It's really best to have an attorney prepare your will. Texas does allow handwritten wills, but I can tell you a lot of sad stories about people who did their own will and it was not legally valid. We have forums. I am on a team that runs the website texaslawhelp.org, and we do have forums where you can prepare your own will. These forms were approved by the Texas Supreme Court. However, places like LegalZoom are not compliant with Texas law. They're meant to be as generic as possible, and Texas law has specific requirements. I had a situation where someone didn't want to spend a will, so she just paid $100 to get something off the internet, and her daughters didn't get along, so the legal fees and the court fees were way more expensive than it would have been if she had paid an attorney to prepare her will. Also, we at AMOS have really great will clinics, so I encourage you to keep an eye on our emails and other announcements, because if you're in the community and we would love to prepare a will for you. Spouses must have separate wills. I just spoke with someone yesterday who explained how she and her husband had prepared their will, and I said, that's not going to work. You each have to have your own will. You can't, as I said before, you can have handwritten wills in Texas. They have to be completely in your own handwriting. This is called a holographic will, and if you go to Texas Law Help website, we have instructions on how to do that. It's really important to keep your will in a safe place and let your loved ones know where that is. Because if your executor cannot find your will, Texas law assumes that you revoked that will. Everyone says, my children all get along. I don't need to worry about this. They're all going to cooperate. You really have no idea how people are going to act after you pass. And if you die without a will, the law determines who gets your property. It's not your favorite niece or this person. It is spelled out by law who legally inherits your property. So you want to be sure to have your wishes in writing. If you cannot find a will, you can still go through the probate process. It's called an application for administration. And it's either independent or dependent. And I'm going to go into detail in a moment to explain that to you. There are extremely limited cases where you can file a small estate affidavit. That is the only probate process where you usually do not need a lawyer. There are a handful of counties in Texas that still require an attorney. That includes Brazoria County. And it's, there's a lot of reasons why you need an attorney to go through probate. And one of them is there's several options, and an attorney is going to know the best way for you to proceed. You have to have an attorney when you're probating a will, because only licensed attorneys can represent other people. You're allowed to be your own attorney in a divorce because you're only representing yourself. You're not representing any other party. In probate cases, you're representing the interest of anyone who inherits. You're representing the interests of any debts any creditors of the estate, and the estate itself is a separate legal entity. So that's not just representing yourself. There are just the two exceptions, small estate affidavits and possibly muniment of title. You may be able to get by without having an attorney, but those are pretty rare circumstances. So probate assets are the property in the testator's name that pass under a will. This includes any real estate that you own and your personal property, such as your household items, your car, your clothing, all of those things. In Texas, we also have non-probate assets. Those are not transferred through probate. If you have properly named beneficiaries, non-probate assets pass in accordance with the terms of a contract. For example, this would be any life insurance policies that you have, retirement plans, or payable on death accounts. If you learned nothing else today, I really hope that you all remember that if you have payable on death beneficiaries on all of your financial accounts and a transfer on death deed for your house, your family may not need to go through probate. You always want to have a will just in case you have forgotten one of your accounts, just in case there's something you forgot to have a designated beneficiary. So probate of will and independent administration are extremely similar. You hire an attorney, and the attorney files an application with the court. After 10 days, the attorney can schedule a hearing. This does not mean that your process is going to go that quickly. In Harris County, you're looking at least 6 months because the courts are just that busy. I think it's a little quicker in Fort Bend County, but in general, it takes some time before you can get in front of a judge. You go to a very short hearing in front of a judge, and sometimes it can be on Zoom. If the judge grants an application for probate or application for independent administration, the person who is appointed the personal representative receives letters testamentary or administration. And then the personal representative is responsible to gather all of the assets owned by the person who passed. They also have to open a bank account for the estate. So this requires your own separate tax ID number. What would happen is someone passes away, you go through probate court. Once you get your letters testamentary or administration, you would take those letters with a death certificate to the bank where your loved one had an account, and you would open up on a bank that is in the name of the estate, not in the name of the personal representative. The personal representative is not responsible for any debts of the estate. There is a legal process where the attorney notifies any creditors. And then the final step is that the attorney, along with the personal representative, prepare and file an inventory. The inventory is a list of the property the person owned as of the date that they passed away. So like I said before, testate estates are those that have a legally valid will. If no one argues, no one files a contest against the will, this is a very easy procedure. A lot of people are frightened by the word probate. And if you have a good will, it really isn't that complicated. And it's a lot less expensive than it is in some other states. So you go to court and you have what is called a prove-up hearing. That's usually less than 5 minutes. The judge just wants you to state that it's a valid will, that you knew there were no wills written after this will, and that you recognize their signature. The judge then admits the will to probate and orders that letters testamentary be issued by the court clerk. Letters testamentary is your permission slip. It's the document that gives the personal representative the right to manage the estate. The attorney then notifies both the beneficiaries of the will and any creditors. And then the attorney and executor prepare and file an inventory. You're also allowed now to do an affidavit in lieu of inventory, which simply states that all of the beneficiaries of the will are aware of what was in the estate. Best possible scenario, if everybody who is an heir is over the age of 18 and they all agree with each other and they file waivers with the court, you can have what is known as independent administration. It's very similar to a probate of a will. and it's not too time consuming or costly. I want to caution you though, please don't ever think that your kids are all going to get along. Nobody's going to fight. That almost never happens. And that's where things get very expensive with the court fees and the attorney costs. Um, Both the person who the heirs decided would be the administrator and two witnesses will go to court. There's another prove up hearing. It's called prove up hearing because you're proving up the facts as to why the estate should be handled this way. It's usually less than 15 minutes. The judge appoints an administrator and orders the issuance of letters of administration, which, like the letters testamentary, it gives the personal representative the right to manage the estate. And just as in the other process, the attorney notifies beneficiaries and creditors, and they file that inventory. It's a little bit longer than the probate of a will prove up hearing because you also have to prove to the judge who the heirs are. Dependent administration can get extremely expensive as it requires strict court supervision. So if your heirs do not agree, or one of them is under the age of 18, your attorney has to file an application for dependent administration. It's extremely slow and expensive. You have to pay all the extra attorney's fees. You have to pay a lot of extra court fees. The court requires the dependent administrator to post a bond. I believe it's usually 10% of the total value of the estate. And every single action has to be approved by the judge. I had a dependent administration because one of the heirs was a child. We had to get permission to have the grass cut every week. We had to get permission to keep the electricity on. It was a multi-year process. And the only time is if there is an estate where the person who passed had significant debt, it can be good to use a dependent administration because it can protect those estates. It is harder for the creditors to collect. And both independent and dependent administration. So anyone who passes without a will, their attorney also has to file an application for determination of heirship. What this is a legal process to make sure that nobody has been left out, that there's not an heir that has been ignored. So the judge appoints a neutral party. It is an attorney known as an attorney ad litem, and they have to do an investigation to make sure that everyone who is entitled to the estate is taking part and has been notified of the process. They do an investigation. They also speak with two disinterested witnesses. Disinterested witnesses are two people who cannot legally inherit. So that would be neighbors. That would be friends from church. And then the prove-up hearing is usually less than half an hour. The attorney ad litem actually goes in front of the judge and explains all the research that they've done. Here are the people that I have found who were legally entitled to inherit. And I also interview the witnesses in front of the judge. And then along with the authorizing the letters of administration, the judge also signs an order that lists all the heirs and how much they are entitled to inherit from the estate. There is another simpler process. It's called probating a will as muniment of title. With good cause, you can file it more than 4 years after the date of death. Probate usually has to happen within 4 years of the date of the passing. If the only thing you need to do is transfer a house, you can use the muniment of title. What it is it's a legal term that says that the document is sufficient evidence to prove ownership of the home. The will has to be legally valid, and all the heirs at law must agree to probate the will. What heirs at law means is those are the people not named in the will, but the people who legally can inherit from the person who passed. They all have to agree to go along with the will. It's a pretty short process. The judge will admit the will to probate, and then the attorney records a certified copy of the signed order and the will, and then that means that the property has been passed to the person named in the will. If you have a very good reason why you did not file the will on time, the judge may allow you to do this more than 4 years after the date of death. I happened to see this in court one day where this lady had lost her husband. years ago, and she decided to sell their home. And while they were cleaning out the house, she came across a safe that had a will in it. And when she explained that to the judge said, okay, it's been more than 4 years, but I'm going to go ahead and let you probate it so that you can transfer title to yourself. There is some new Texas law that you might be able to file pro se. That is, you might be able to file without an attorney if you are the only beneficiary that there is. Small estate affidavits get confusing because a lot of people think, well, if I don't have a lawyer, I can use a small estate affidavit. That is not true. You can only use a small estate affidavit to transfer a house, any type of real estate, if the following conditions are met. It has to be a surviving spouse or a minor child. It cannot be an adult child. All of the heirs have to agree and sign that small estate affidavit along with two witnesses. You cannot use this procedure if there was a legally valid will, and you cannot use this procedure if the value of assets is lower than the debts of the estate. So say someone had property worth about $25,000, but they had $40,000 in credit card debt, they cannot use a small estate affidavit. The home is not included in the value of the assets. The homestead is excluded, and the estate has to be less than $75,000. Most counties in Texas will allow you to do this without an attorney. However, I know Brazoria County, you do have to have an attorney, and I believe there are a few others. If you are an adult child and the only thing that you need to transfer is a bank account, a retirement account, something financial, you may be able to use the small estate affidavit. You want to check with the bank. You want to check with whoever is in charge of any financial accounts and ask if they will allow you to file a small estate affidavit. That will save you the fees of probate. I believe a small estate affidavit in Harris County is just under $400. Every time I talk about wills, people want to know about trusts. Trusts have the best promotion in the world. Everybody on social media says, don't have a will, have a trust. Trusts do have some good reasons, some valid reasons to have a trust, but in Texas, you really don't need one in most cases. Wills are not that complicated, and probate is not as expensive as it is in other states. So like a will, a trust is a legal document that states how your property is to be distributed at death. It can transfer both your real estate and your personal property. A lot of people do their own trust. This is a very bad idea because if your property is not properly transferred, the trust is invalid. It's just an expensive stack of paper. If you don't transfer a home correctly to a trust, you lose all of your property tax exemptions. If you don't transfer your bank accounts to the trust, your heirs are going to have to go ahead and probate. Attorneys are very expensive to do this, but one of the reasons is that if they are a good attorney, they have someone in their office that makes sure that everything is transferred correctly. A good reason to have a trust is if you want to protect assets to qualify for Medicaid. Elder law attorneys specialize in making sure someone can qualify for Medicaid sooner by transferring their property to a trust. Trusts do allow you to have control after your death. If you have younger children, even if you have college age children, if you have a family member that's not going to be responsible, they do allow you to protect those people so that they only get distributions of funds for a good reason. Once again, the best thing you can do in Texas is make sure that you correctly name beneficiaries to all of your financial accounts and use transfer on death deeds for any property. That reaches the same goal, has the same ending as a trust. You always want to have a will because there could be something that you've forgotten, but this really does cover most needs. So a lot of us inherited homes from our families, and we don't realize that we don't have clear title. It was given to me in a will. It's my house now. Or, even it's a family home. It's always belonged to the family. If you don't have clear title, you don't qualify for assistance if there's a natural disaster. You will not be able to qualify for FEMA or for any of the state programs. And you also won't get your property tax exemptions or deferrals if you do not have clear title to the property. Clear title means that nobody else has a financial interest in your property. It means that there's no question of ownership, and someone could go to the deed records in the county clerk's office and clearly see how the property transferred to the current owner. If property isn't legally transferred or deeded to the subsequent owner, the title is called cloudy. That happens when somebody dies without a will or the family doesn't manage the estate. It gets confusing because a title and a deed are two different things. A title is just a legal right. It is not a piece of paper. It's just a legal right that shows how strong your ownership claim is. Having clear title means that there's not any unexpected claims on the property. There's not any tax liens. There's not any other type of loans on the property. A deed is the actual piece of paper that transfers ownership to the new owner. When I used to be at Earl Carl, and we had people coming all the time after hurricanes, after floods, after winter storms, because they would apply for FEMA, they would apply for the state assistance programs, and they cannot give you any financial assistance for repairing your home if you don't have clear title. You cannot get good property tax deductions if you do not have clear title. And if you have clear title, you can apply for home improvement and other types of loans. So again, it's really critical after someone passes to probate their estate or go through another process to make sure that the people living in the home have clear title. So besides going through probate court, there are a few other ways that you can clear title. If it's within 4 years, you want to go through the probate court. If it's been more than 4 years, if you have a very good cause and everyone in the family agrees, you can file an application to probate the will as muniment of title. There's a third way, which is a petition for adverse possession, and that's a court process that I think most people have heard of. So like I said, within 4 years, you want to go through the probate court, and an attorney can help you with that unless you qualify, because you're a surviving spouse, you qualify for a small estate affidavit. The muniment of title, if there's a legally valid will and everybody entitled to the estate agrees, you can probate the will. There's New Texas law that says if there's only one person, say both parents have passed and there's only an only child, that person could probably go through the process without an attorney. Small estate affidavit works if there's no legally valid will, all of the heirs agree, and a home is going to be transferred to a surviving spouse or minor child. Again, it has to be signed by all the heirs and the disinterested witnesses, and you do not have to appear in court. If all of the elements of the law have been met, the judge just signs an order. Adverse possession is the type of case that we've all heard about where a person can obtain legal ownership based on their continuous occupation without permission on the property. If you have permission to live on the property, you cannot obtain title through adverse possession. And you have to be there for a pretty long period of time. Depending on the circumstances, it varies, but it's usually at least that you have lived there continuously for 15 years. An easy way to transfer title, especially if some time has passed, is through an affidavit of heirship. That's a legal document that gives property to the heirs of a deceased person. I use it if the homeowner didn't have a will or if the will hasn't been probated within 4 years. This is something you can do on your own without an attorney. We have a form with instructions at Texas Law Help. It doesn't have to be signed by any of the family members. It just has to be signed by 2 people who were disinterested witnesses. Those are people who knew the deceased person and their family history well, but they don't legally inherit. You have to include the full legal description, which you find on the deed. I see this all the time. People think you get your property tax bill and it says legal description. That is not the full legal description. You need to get a deed and copy that description. You can get a deed from the county clerk's office. There's an online site, texasfile.com, where you can also order a deed. You have to file the affidavit of heirship and the county where the property is located. There is a filing fee. It is a little bit more expensive in Harris County. It's going to be roughly $50. It depends on, it can be less. It depends on the length. You get you're charged per the page of the document. I'm using affidavit a lot, so I just want to clarify a small estate affidavit can only be used if there's a surviving spouse or child under the age of 18. You can use a small estate affidavit for adult children if all you need to do is transfer things such as bank accounts. Affidavit of heirship is the best and least expensive way to transfer a home to a surviving spouse, adult children, or other transferees, and you can use that if there's no other estate asset. Every time I help people clear title, I want them to make sure that they prevent this from happening in the future. Miss Nia often has what's called a Todd clinic, and I urge all of you to go. A transfer on death deed is a simple, inexpensive way for you to transfer your home or any other real estate to somebody else upon your passing. It does not affect your rights during your lifetime, so you still own that property 100%. You can sell it, you can use it as collateral for a loan, you're still entitled to your tax exemptions. The beneficiary has no rights until the owner passes away, and the owner can also change the beneficiary or cancel the deed entirely. There are two very important issues about the transfer on death deed. It has to have the correct legal description from the deed, and it has to be filed in the county where the property is located before you pass away. Ladybird deed is very similar to a transfer on death deed. It's been around a lot longer. I prefer the transfer on death deed because it's covered by law. Ladybird is not mentioned in any of the Texas statutes. The one good aspect of a ladybird deed is if the homeowner is incapacitated, for example, they have dementia, the person who is their power of attorney can sign a ladybird deed. Both ladybird deeds and TODs avoid probate and Medicaid estate recovery. Medicaid estate recovery is a process where if you use Medicaid to pay for your nursing home, after you pass and any surviving spouse passes, Medicaid can seek to recover their expenses by going through the probate course and requesting that the judge sell your home so that they can recover their expenses. So if you have a TOD or a ladybird deed, the houses do not transfer through the probate court and they are not able to seek recovery. You can go over this. Ms. Nia will send the presentation to you. This is just a chart that explains the differences between the TOD and the ladybird deed. TODs allow you to include alternate beneficiaries, and TODs give the people who own it more right. Ladybird deeds can make it more difficult to sell the property. Ladybird deeds also have to be prepared more than 5 years before the homeowner applies for Medicaid. TODs do not. So please think about preventing this problem in the future. We have a transfer on death toolkit at Texas Law Help. It has forms that were prepared by the state of Texas. You want to be sure to find that correct legal description and do not use the description from your property tax bill because that could cause the transfer on death deed to be invalid. We are blessed in Harris County with a variety of resources. You've got our website, Texas Law Help. We have a program for people over 60 called the Hotline for Texans that can help with long-term care and estate planning questions. Earl Call Property Preservation can help you with clearing title. And then we also have Lone Star Legal Aid and Houston Volunteer Lawyers. Legal Line is a way for anyone to ask free questions from attorneys. And I always recommend calling the Houston Lawyer Referral Service for referrals to attorneys. Thank you so much. I am going to pass this over to Mabel, and I'll be around to answer questions after the full presentation.
Thank you, Miss Lisa.
Thank you.
All right. Miss Mabel, you're up.
I'm up and I'm just about to share. All righty. Okay, before we get started, I did want to mention, make sure that everyone is introduced to my colleague who's in the chat room, Donna Pensick, who will be more than happy to answer any questions that might come up as I go over the presentation. And so we're going to start with, so property taxes are usually something that must be attended to when a title change is occurring. So one of the reasons we tag along with Lisa in these presentations, that us meaning HCAD as well as the tax office, is to kind of make sure people understand that particular part of the clearing title process, because you want to make sure that you do, otherwise it can often lead to additional expense and delay in terms of getting your property properly taken care of. So HCAD is Harris Central Appraisal District. So we are the folks that actually value property in Harris County. And that value is upon which your taxes are configured by the taxing jurisdictions. And when I say taxing jurisdictions, taxing entities, I'm basically talking about the folks that you pay property taxes to. For instance, school districts in the city, the county, maybe a community college. So property taxes in Texas tend to be a little more outsized than they might be in other states. And one of the primary reasons is because Texas doesn't have a state income tax. So the money for funding local services comes primarily from property taxes. Believe it or not, in Texas, in Harris County, there are over 600 taxing entities. You may actually only pay taxes to 4 or 5 of them. It simply depends on where you live. So let's just get into that a little bit, and a couple of other issues that I wanted to talk about in terms of making sure that there's certain features within the property tax code that you're going to want to know about as far as exemptions and making sure that those taxes are paid. So anyway, with central appraisal districts, there's one in every county. We're the Harris Central. We do it for Harris County. And one of our other key roles, as I mentioned earlier, is that we administer exemptions on property. And exemptions are sort of a discount on your property taxes, if you will, based on certain qualifications that that individual homeowner has. And that's an important point to remember, because when you inherit that property, there may be exemptions on that property that the previous owner was entitled to, which you may not be. So you want to make sure you understand that process and how to clear all that up. And if that's going to be your primary residence, you're going to want to get your own exemptions and do it as quickly as possible so that you don't give away money, which when you don't have your appropriate exemptions attached to your home, that's exactly what you're doing. One of the other things we do of course, is we certify appraisal rolls. We currently, this time of the year, we're typically meeting with homeowners as they want to try to make adjustments to whatever their valuation is that HCAD has assigned to them. And then by the end of the summer, we typically certify those appraisal rolls to the taxing jurisdictions, which basically means we say to them, okay, this is how much tax revenue that you can expect to come in, which helps them establish their budgets and spending plans for the next year. So we're overseen by a chief appraiser, that's our CEO, as well as a 9-member administrative board. One of the things that each year you get from HCAD, this is just the quick copy of the upper part of the annual value notice. And on that value notice that we send out each year is our opinion of value on your property. And there's the appraised value and the market value. Always important to remember that taxes, if you're a homeowner, are going to be based on the appraised value, not the market value. The market value is that which we think your property will sell for on an open market to a willing buyer. The appraised value is often lower, and it's generally lower because of the benefits that are received when you have exemptions. So, okay. So next, and for some reason, I don't know why that is not moving. Okay, let's see. Oh, here we go. Just quick, this is just to show, because I mentioned earlier that we do this on an annual basis. Each year you get that valuation notice. So the property tax process is a process that takes place each year, all segments of it. So one of the things to remember is that the date of appraisal for a property is based on January the 1st. That means whoever owns it, whatever condition it was in on January the 1st, that is what our opinion of value is going to be based on that date. And then, of course, May 15th is the infamous protest deadline. If you own a home already or maybe have exemptions, you're familiar with that. Then, of course, we go through that process I just recently described in the summer, and tax bills, so that taxing jurisdictions can mail out their bills in the fall. And then, of course, any taxes are due immediately upon receiving the bill, but if they're not paid by January 31st, they are delinquent. So now we get to the part about what's important to understand a little bit about how the exemptions work, so that if you are working a clear title, you kind of have an idea on where to get started and what to do. So with property tax exemptions, they save money to folks that have them. They do have to apply for them, and of course, HCAT administers them. They exempt a portion of your property's value from taxation. So, if you have a $300,000, say the home is worth $300,000, and you have, basically a school tax exemption of $140,000. So that means that the person is only paying property taxes on $160,000 of that person's value. So as you can imagine, based on property tax rates, then that's quite a bit of savings on your school taxes. They're also, so those are and that's where the appraised value comes in, and that's what taxing authorities use based on minus the exemptions, and that's what they use to calculate your tax bill. So, appraised value is important to remember. So the most common one that most individuals are going to have at their primary residence is the general resident homestead exemption. That's because they own and occupy that home as their primary residence. If that's all you need in order to get that general resident homestead exemption. There may be some other exemptions. Particularly important to remember is whether they have an over 65 or an over 55 surviving spouse. They may have a disability exemption. They may be a veteran who has some form of a disabled veterans exemption. And then, of course, there are a few other service-related exemptions as well. The general resident homestead exemption is something that I mentioned everybody probably, if that is your primary residence, you should definitely have, or they will definitely have. And that gives an individual a 10% appraisal increase cap, which basically means that if property values are rising in that person's area, they are going to be protected by the fact that in a given year, their property value can never go up more than 10% in terms of keeping their taxes to that low. So that means that each year, whoever had that exemption, they're going to be protected by that 10% appraisal increase cap. There's also, for the general resident homestead, I mentioned they get that $140,000 school tax exemption, and that's something that happens throughout the state because that is required by the Texas legislature, that all school districts offer that to folks who qualify for the general resident homestead exemption. Depending on where you live, you may also be eligible, that homeowner may also be eligible for other exemptions that different jurisdictions offer. So they're going to be different ones. I think HISD, for instance, offers an additional amount to that school tax exemption. Some other ISDs in the county do not. And then there are other special districts exemptions that you might become eligible for because you have the general resident homestead exemption. Now, the over 65 and disability exemptions, these are two separate exemptions, although you can only have one or the other. But they basically provide the same, because they basically provide the same benefits. The over 65 is something that any individual who's turning over 65 would qualify for the entire year that they turn 65. The disability exemption is one that you would also qualify for the entire year and eligible to receive those benefits. You have to be part of receiving SSI, or if you're not receiving Social Security, a person can qualify for that by having their physician provide HCAT with a statement. And as I mentioned before, HCAT is the one we administer, therefore we grant the exemptions, which are then factored into the information that we have on your account, which allows the taxing jurisdictions to know what benefits or how to reduce your taxable amount. The benefit for either exemptions, just to go over a couple of those as a reminder now, I mentioned the $140,000 school tax exemption. Once you turn 65, you also get an additional $60,000 exemption, and your school taxes are going to be limited or frozen at the rate that you were paying the year you turned 65. They will never go over that amount. Can they go down? Yes, they can, if the value of the property falls, but they will never go over that amount unless you do something where you have a major upgrade, such as you build you add additional square footage to the home, or you put not necessarily general maintenance, but you do something like adding square footage where you've actually increased the value of the home, then that school tax ceiling would be kind of readjusted for that additional value. You also get some eligible for something called a tax deferral, where you can pay taxes in installments. And other exemptions might be granted by, again, depending on where you live. And then there are special payment options that folks over 65 may have with the tax assessor collector. So all those are important things to remember, not only as a homeowner, but if you are assuming title, you want to kind of be familiar with some of the options that person you're taking over the property from may have taken advantage of. So the most common, again, another exemption might be the over 55 surviving spouse exemption. That exemption is for anyone who has been married to a person who had reached 65, and because that person had reached 65, their spouse, they became eligible for the property became eligible for the over 65 exemption. If that person passes away, then the person who hasn't yet reached the age of 65, as long as they are 55 years of age, they will be able to continue those exemptions. All of the exemptions that they were receiving under the spouse's 65 exempt age qualifications. Then there's some veterans exemptions that an individual, if they were a veteran, they may have had, such as the total VA exemption. Then there's a total disabled veteran surviving spouse, and certain kinds of disabled veterans exemptions based on their degree of disability. Excuse me. There are also some exemptions available for the surviving spouse. And this one, this may not necessarily apply, but just quickly, if someone moves into a home now and there's something called an immediate resident homestead exemption, which as long as you used to, remember I mentioned that January the 1st is kind of the magical number for HCAT in terms of when you qualify and when we value the property as of January the 1st. So it used to be you could only receive the exemption if you had to own the home on January the 1st to receive it. Well, a few years ago, the legislature decided to change that so that a person could receive that homestead exemption immediately upon owning and occupying the house. it would be prorated. So if you moved into the home in April, then you would get around 8 months worth of that exemption prorated. And then, of course, the second year that you move in is when your full eligibility begins, and you also get that cap eligibility year base, so that if values start to rise, then you're protected by that no more than 10% increase. Now, if the home was previously owned and someone was receiving those exemptions, then that owner's exemptions are going to remain on the property for the rest of the year. Tell you the best case, a great case scenario, and that is if you're moving into a home and say the previous owners were a couple or an individual who had been receiving their over 65, who had lived in the house for a fairly long time, so they'd had that general resident homestead exemption cap each year. And then they also were maybe perhaps in their mid-70s. So they carried that over 65 exemption for a number of years. Well, that first year, in terms of taxes, you may well make out like a bandit because of that. You're going to be receiving that's over 65 person's exemptions. Now, the following year is when the taxes are going to be based on your qualifications. So it makes it very important then to make sure that you have at least that general resident homestead exemption so that you can continue to save some money there. Now, the heirship exemption, there may be some folks out there listening to me now, or you know of folks who are living in a deceased relative's property, a property that is still in a deceased relative's name. That is called heir property. And it may be in that deceased relative's name because there were other heirs to the property. Maybe there were two siblings. One of them lives on the property, the other one is off living somewhere else, and maybe they have their own homestead exemption. The heir is normally, or it has been in the past, difficult for an heir to receive a general resident homestead exemption or an over 65 exemption because they don't have 100% ownership in the property. They may say, for instance, if there are three other siblings, they may have only qualified for 25% of the exemption, or if there were just two of them, 50% of it, so not the full amount. There is a process that folks can go through that we will be happy to walk you through here at HCAD that will allow you to get that 100% exemption status, and it's not going to affect any ownership rights of other heirs. It simply gives you, the person living in the property, the person who's probably taking care of everything, the right to claim that homestead over 65 or disability exemption. So that's something that's very important to keep in mind if you're living in an heir property where there is no clear change of title because there are multiple heirs. And one of the ways you would apply for that heirship exemption is, of course, through our exemption application, and it's Section 3 is where that heirship exemption question may trigger some additional questions and some additional steps to follow in order to get that heirship exemption. Again, the several important questions that are going to be asked, and it's going to tell you what you need to do in order to qualify. So that is on our exemption application. It's also several other places on our website, which I'll mention to you in just a minute. As I said, it's available in several other places on our website. If you are ever confused about whether or not you qualify for a particular exemption, we now have something on our website that'll kind of walk you through which exemptions you might be eligible for. And you'll see it's kind of shown as our exemption wizard on our website at www.hcad.org. And basically, it asks you a series of questions, and depending on how you answer them, it will tell you which exemptions you may be eligible for. So you'll know what to apply for. hopefully clearing up confusion about which ones you may qualify for, and helping you through that process. So if you have any doubts or questions about exemptions, then feel free to please go out on our website and check out this wizard and fill that in, and you should hopefully get some answers. Now, this is also something I want to point out that is very important in terms of reminding reminding property owners about the fact that they do have exemptions, and giving quick pause to make sure they're still eligible for those. And it's called an annual exemptions confirmation card that we send out. It usually goes out in December or early January, and it basically lists the exemptions that are available on that property. These are mailed to each property owner, and it's going to list the exemptions that are available, that are currently on the property. If everything is okay, and then and they're all correct, then and nothing's changed, you just kind of throw it in your drawer. If in fact something has changed, then that is when it is your responsibility to notify HCAD, so that any exemptions that that property or you may be receiving, which you are not eligible for because you're no longer the owner, you want those to come off, because you don't want 2 or 3 years from now, when the district does have that information on hand, that you've been receiving exemptions that you are not eligible for, then by state law, they may be required to go back as far as 5 years to collect any back taxes on which you underpaid because there were incorrect exemptions on your property. So it's really important, and this is also a good reminder for if you are taking over a property of a deceased relative, to remember that this card is a good reminder. If you don't recall receiving the card, then you may want to give HCAD a call, or just to make sure that those exemptions are correct on the property, because this particular postcard is not forwarded. It comes back to HCAD, and if it does come back to the district, then that's kind of a signal to us that ownership may have changed. And while we'll make additional efforts to confirm that, at some point, if we're unable to, then those exemptions can come off the property. And you don't want that to happen if in fact they are you are entitled to those. So just kind of keep an eye out for this card, end of the year, first of the year, just to make sure everything is correct. And then finally, this is our contact information. We're at 130, we're out on the Northwest Freeway, but we do make it possible. We try to make it as easy as possible for you to reach us via phone, via online, which you can see down here, where you can contact us at hcad.org/contact us. And you can also find out a lot of helpful information on our website. You can do property searches. There are a number of videos out there that will walk you through some of the specific topics that I've mentioned today, as well as others. And you can also, if you need to schedule a conference with an appraiser or someone else, you can do that as well. We also have a number of educational events and workshops that we do each year. And that is my presentation. I'm going to turn it over to the tax office, which is going to follow in terms of what happens after the appraisal process and the certification of the bills takes place, which is our role. And then what do tax assessor collectors, what you can expect from tax assessor collectors after that. So I want to thank you. Thank you for taking the time to listen. And now I'm going to turn it over to Vicki from the tax office. All right, Vicki.
Okay. Hi, good good afternoon, everyone. Can everyone hear me just fine?
Yeah, look,
Hello?
might want to turn it up just a little bit.
Okay. How's that?
Better. Yeah.
Okay. Can you hear me now? Okay. All right. Perfect. I apologize. The PC that I'm using, the video is not working. So anyway, good afternoon, everyone. Again, my name is Vicki Fetzer. I'm with the Harris County Tax Office with Miss Annette Ramirez. So I am here to present what Harris County Tax Office does. So here we go. So what we do here at the Harris County Tax Office is that we register voters, we collect property taxes, and we process auto services such as auto registration, title transfer, and other vehicle services. We generate about $1.4 billion from the auto services for Harris County and state of Texas. $8.5 billion from property revenue, tax revenue, $95 million from hotel occupancy taxes and sports authority, $2 million from residents served in person at our 16 branch locations, and 2.7 million registered voters. So the life of the property tax cycle starts from the appraisal the appraisal district, so the Harris Central Appraisal District, HCAD. So from January through about May is when the appraisal district noticed the appraised value on properties. And then from May through July is when the property owner and HCAD, communicate regarding their appraised value or if they're wanting to protest their values. And then from July through October is when the governing body or the taxing unit sets their tax rate. And then by November, we should have the tax statements available to be mailed out to the property owner, and we collect taxes until June. So as of July 1, it goes to the collections office if the account's still delinquent. How we calculate your tax bill. Again, we get the taxable value from the appraisal district's office. We multiply that by the taxing unit's rates, and then we generate a tax bill. There are some recent property law changes that we've implemented, of course, and this is only for the school taxing unit, so it's not for all taxing units. So just regarding the school, the general homestead exemption did increase from $100,000 to $140,000. Also, the over 65 and disability homestead increased from $10,000 to $60,000. So the exemption qualification is for the survivor, spouse, of veteran whose death was due to a service-connected condition. We also have temporary exemption for improvements. And then another new change is the business personal property exemption, which increased to $125,000. So any value that's below that amount would not get assessed any taxes. We have two examples of property on this one. So on the first property that's appraised at $400,000, if the home does not have any exemptions, they're paying about $8,500.88. With a homestead exemption that lower your tax liability to around $5,582.93. And then if you have the additional 65 and over or the disabled exemption, you're looking at $1,516.20. And then our next example is based on a property that is appraised at $250,000. Again, with no exemption, you're looking at $5,313.05 with the homestead exemption that lower it to $3,028.23. And if you have the additional 65 and over or with a disability exemption, you're looking at about $71.63. Maybe we'll talk a little bit about the tax limitation known as a tax ceiling or tax freeze. So again, with the tax only or tax free, it does limit the increase of the taxes on the school and some other jurisdictions, but not on all property taxes. It does apply to homestead or property owners who are disabled or age 65 and older. We, on the tax deferral, it postponed, the tax deferral exemption is a qualification for anyone that owns, they live in the property, they're age 65 or over, they're disabled or disabled veterans. So they are allowed to apply for the tax deferral. It's not automatic, so you have to apply for it. And what it does is it postpones your tax payment and prevent foreclosure. You're not going to be paying any penalties, but the 5% interest per year. The deferral will end once the property is sold or there's a change in ownership. And you'll have 181, or after the person passes away or if there's a change in ownership, the person that's responsible for the taxes will have up to 180 days to pay any taxes that's due on the account. So on the 181st day is when the regular penalty and interest will revert back on the account and be, reassessed back on the account. Another important message is that if you're thinking about applying for the tax deferral, you must consult with your mortgage company because most mortgage company doesn't recognize the tax deferral. So if you have a mortgage on your property, please consult with your mortgage company first. We have a quarterly payment plan option for property owner who's age 65 and over, they're disabled veteran, or survivor spouse. So we offer 4 equal installments that is due by the end of January, March, May, and June. So if you make your payment, timely by those due dates, then you pay no penalties and no interest. However, let's say that you, make your March payment late, you would only be paying that 7% late fee on that particular portion. So it's not going to be on the whole tax amount, just on that portion. So a quarter of that payment. We also have delinquent payment plans for, for regular homestead property or non-homestead, and we also offer a payment plan on personal business account as well. The payment ranges from 12 months up to 36 months. After you enter into a payment plan, it is, it will help you avoid the 20% collection fee that will be assessed on July 1 if you do not have a payment agreement. So without the payment agreement, any delinquent taxes can be foreclosed or, go into an active lawsuit by the collections attorney. If you're interested in setting up a payment agreement, you can, request a payment agreement online through myharriscountytax.com. You can give us a call or visit any one of our 16 branches. We have a new feature for our payment online. It's myharriscountytax.com, and you can go to this link by going to our tax office website, hctax.net. We're providing homeowners more convenient ways to pay their taxes. You can set up a due date reminder. Your payments are made securely. You can view your receipts anytime. We also added a new feature where you can prepay your taxes for future tax years. So for an example, you can start prepaying your taxes for 2026 tax year before they even come out. So by the time the 2026 taxes comes out in November, you would have, saved up, that money to pay towards your taxes. Again, if you would like to sign up, you can just go to myharriscountytax.net, or you can go straight to our website, hctax.net, and it will have a link and it will take you there. Our payment option is, again, by online. Again, you can go through our website, hctax.net, and you would click on that link, myharriscountytax.com. You can mail in your payment. You can make your payment by phone. The only thing with the phone payment is that if you have multiple tax years and if you make a payment by the phone, it will apply to your current year. You don't have an option to make payments towards your prior year. So that's the only bad thing about our phone system right now. Or you can come in person at our one of our 16 branch locations. You can also make the full payment or partial payment again on prior tax year if that applies to you. Again, not by phone. So on credit card, there is a convenience fees on credit card, which is 2.40%. Check and e-check, I believe there are 50 cents now. And then, of course, cash at the branch. We are committed to reducing your tax burden. We offer payment plans. We offer a workshop. We offer prepayments. And, of course, you can sign up for e-bills. That way you get the electronic bills when it first becomes available, to you. So that way you don't have to wait for the mail to come to you, or you can always go to our website and view your bills and pay your bills online. Again, we are here to help. You can email us, by going to our website, hctac.net. You can give us a call or you can email us. And that is the end of my presentation. Please let me know if you have any questions.
Uh-oh, sorry. Okie dokie. Let me see. We have a few questions. Hold on. Trying to go back because my computer was kind of glitching here. Let's see. If Miss Mabel, this question is for you. And if your property is in a trust, do you still qualify for exemptions?
Yeah, I think Donna answered that. I'm gonna let her answer that. That there's certain information, specific information that we need. Donna, you want to address that one?
Sure. All right. When you write up the trust, you want to make sure that your trust, as Lisa said, has the verbiage needed. And what it is, it has to do with your primary residence, and you need it to say that you may occupy your primary residence rent-free. So that's in the Texas Property Tax Code. And we do actually have the Texas Property Tax Code on our website under Help, Laws and Rules. So if your attorney needs that, it's right there. And what happens is I've had property owners who buy the property and they're putting it into the name of the trust itself. So to apply, you'll be applying for the exemptions. And then you also need to have a copy of the trust with that verbiage. And if you put the name in the trust and you already have exemptions, you're going to want to requalify if the application, your driver's license, and a copy of the trust, and ask us to reinstate your exemptions. So you may always check with us if that happens, and the requirements that we have at help@hcad.org, or we do have a web form inquiry underneath contact us. So that's the main verbiage that we look for. So.
Okay. That was the only other question that was in the chat that I see. But there was another question that was emailed to me in advance. So Miss Lisa, this one's for you. Or actually either one of you guys. How would somebody go about obtaining a hard copy of their deed or their warranty deed?
The easiest way would be to contact the county clerk's office. There is a website. Let me double check what it is that I verified my own deed with. I'm just looking for it because there is a website. Yeah, it's called texasfile.com. I'm not affiliated with them at all, but you can look up your deed that way and order one. But I recommend going through the clerk's office.
Okay.
Because you can get an official, I believe it's a certified copy. So that would be the best hard copy to have.
What's the process for Miss Mabel for changing the name on HCAD records if it's an inherited property? What do you need to do that?
So we're gonna need that from the clerk's office. Donna, you want to address that? And I will mention that a lot of people think that that information, that HCAD gets that information automatically. We don't always from the clerk's office, so I'm gonna let Donna take it from there.
Mia, what was the specific question? Is it air applying for
What does HCAD need to change a name on an inherited property?
Oh, well, it's some of what Lisa said. They would need that recorded affidavit of heirship or the recorded deed. And that transfers the property from the estate to the heir or whoever it transfers to.
And Donna, I wanted to just mention too, can you mention how that it's important for the property owner to follow through on that because we don't always get in a timely manner that information from the clerk's office.
Well, and I do tell people, like they'll call and they'll say, I'm receiving bills and I sold this property 2 years ago. And I'll let them know that someone does have to inform HCAD. We maintain the records, but we need the official documentation to do that. And sometimes we don't get them all automatically. So we do have a form on our website to change ownership or mailing addresses, and we need that recorded deed, the probated will, the recorded affidavit of heirship to have any type of ownership changed. And it can take some time once you've submitted it, but you'll know it's complete when you see it updated on the account on the website.
And how soon after someone passes are you eligible to submit an affidavit of heirship or that the forms that you guys require to get the property switched over?
Well, they can submit it whenever they have the official documentation. So, yeah, as soon as they have the recorded affidavit of heirship or a recorded deed or a probated will, they can submit it to us with the death certificate. That also has to come to us.
Miss Lisa, this is a question that I had for you, or if you could explain the process to a lot of people. In addition to folks sometimes not understanding or knowing that they have to do something with their will, that there's that process, there's that extra step, even though there is a will. A lot of times attorneys don't do the extra step, even though you probated a will, but getting the property actually switched over. So after the will has been probated, it's been, agreed that these are the beneficiaries that are supposed to receive it. Who files that paperwork or that new deed or that affidavit or whatever else to make sure it gets switched over after the probate process
The
has?
attorney should, but I have run into people asking me questions about that too. The attorney should prepare a deed to transfer the property to the new owner, or
Mhm.
if it's an affidavit of heirship or something like that, the attorney should be filing it. Now, an
And is that
affidavit
stuff?
of heirship, a person could do without an attorney, and then they would be responsible to go to the county clerk's office and record it.
And is that something that people potentially or should put in their will or make sure that they know that, hey, when I pass, you make sure that you get this attorney to do XYZ, because a lot of folks don't know. They just don't know, and then it just doesn't get done.
It's not something that usually happens in a will. That's something where we need community education. Because
Okay.
Texas law is very specific about what you say in a will, and instructions like that wouldn't be in it. It's
Mm,
kind of like hoping on faith that the attorney does their job, but I know that doesn't always happen.
mm, okay. Um, there
So if you
was
are so this is a good lesson. If you have someone who's going to inherit your home, let them know what they need to do.
because the attorney won't always do it, or at least follow up with
Correct.
making sure that it gets done.
I'm very sorry to say it, but that's correct.
Yeah. And the last couple of Todd clinics, we had quite a few people that happened to. They showed up at the Todd to try to get the Todd completed, but realized when we looked up property records that it was still never switched. And they
Oh,
like, well, we have the will is right here that says that I get it, but nobody ever actually still did anything to transfer it over. So,
yeah. I mean,
you
the
know,
will has to go through probate court, and then the attorney needs to file something with the clerk's office so that it's on record that somebody new owns it.
And then that deed then needs to come to the appraisal district.
Yes, and then it needs to go, the person who inherits it needs to file their homeownership exemption paperwork with the appraisal office. And
There's
it's
a lot of
the appraisal district has a great website. It's spelled out and it's easy to figure out how to do it, but that has to be done. None of it's automatic.
I have a question, and maybe there is or there is not. I know everybody's situation is not the same. Is there like an instruction sheet or something that kind of, you know, this is step one, you complete your will. Step two, after you pass, this is what, you have to do to file an application for probate. Three, this is, make sure all documents are done this way or you receive letters testamentary. Four, make sure property is switched over. Like, is there an instruction manual or something somewhere that
Not that
you
I'm
can
aware of,
do
and
that?
that would be something really nice to do. That's something I'm going to make a note for our website to have something like that.
Yeah, because it's too much.
It's a lot.
Okay, I gotta do this over here, and then call this one here, and then and have this one do this, and and one thing that we do talk about, or that we try to mention or to remind people during this presentation, is to allow yourself time to give yourself a little bit of grace, allow yourself time to actually grieve and go through the grieving process
Mhm.
without having to be bombarded with all of these kinds of thoughts and feelings and trying to figure out this and figure out that, and being stressed out. Now you've got you know you have to think about your mental capacity at the time when you're trying to go through grief and handle people's affairs and things. You're not thinking about all of this kinds of stuff and what's supposed to
No,
happen. I've seen all over. I order from Temu, so just bear with me. But Temu, from Amazon, all these different things. There's a book that is a little instruction basically from yourself to your heirs or your beneficiaries. And the front of it, it says funny stuff like,
Mhm.
now I'm dead, but I'm still in control. So here's what you need to do next, kind of thing. That here's the book that's got all of my
I've
bank
seen that.
account
Yeah, it's
information. Here's
great.
all of my bank accounts and who's the beneficiaries and the insurance policies and phone numbers, and this is where I'm supposed to be buried and all of that kinds of stuff. Get those little books. I mean, they're like $10 or something like that, and write all that stuff down so that you can give it to. So if there is no manual like this,
There is
then
not.
at least you've got some place to start that's got all this in one space to hand off to your heirs. That'll save a whole lot of trouble and a whole lot of grief and mental anguish
This is
as
where we
somebody's
all
trying
need to
to,
communicate with each other.
yeah, communicate. And it's unfortunate in a lot of various communities that people don't like to have these kinds of conversations as though they're not going to die. uh,
Yeah,
I heard somebody say earlier today, I was at another meeting. She said, um what was her, um none of us will ever get out of this life alive.
that's right.
None of us will ever get out of this life alive. So, why not? So either you want to get old or you don't. So if you do, then make the plans and the preparations for what needs to happen and what needs to be next for your loved one. So that's a great gift to actually give. There was another question here that was emailed. It may be a little bit outside of our scope, but I get the gist of the question. What methods do you use to do valuations of land and property? I'm a financial planner and I'm looking to make sure that I'm aware of all possible issues that my clients may encounter. And I'm assuming as they're planning for retirement, or, you know, is there something for people making these kinds of preparations that they should know in particular, Ms. Mabel or Donna?
So that would be a question for our appraisers or valuation analysts. So I would suggest that they maybe call up and have a conversation, ask to speak with someone and have a conversation about that, because those are done. We may do something like that in a separate workshop, but we're just not equipped to answer that question today.
I will say that also from a lot of the Todd critics, other issues that have arisen coming from clearing title issues when you're leaving property to multiple heirs, especially now that hurricane season is coming up, being able to qualify for certain benefits
Mhm.
when you're transferring property and transferring assets, and this particularly for this financial planner. Um, uh, not not inadvertently disqualifying yourself for public benefits when you're getting older. So when you're having all these different assets and things put into your name or transferred out of your name to someone else, if you're over a certain age and you're trying to apply for Medicare benefits, then you don't want to inadvertently disqualify yourself for those kinds of things. So keep that in mind. And then um, when filing for like a Todd or something like that, where somebody ran into an issue where they tried to apply, they were one of the heirs that received inherited property. They tried to apply for disaster assistance for one of the houses because there were multiple heirs that were on the deed, that they could not qualify for the disaster assistance because they look at the ownership of all owners listed on the deed. They look at the assets of all of the owners listed on the deed.
Every
So
heir
Yeah.
has to
every
agree.
heir, so if you got 4 or 5 people, all of you guys' assets, even though there may be one person living in the property and one person taking care of it or what have you, you potentially could not qualify for some of those disaster programs because more than you actually own the property. So do
Correct.
consider
Mhm.
that.
That is correct.
Um, oh, the form that I was talking about or the book that I was talking about, it's on Amazon. Just search um and not that I even want to tag Amazon here or give anybody a plug, but you could order that book from anywhere offline. There's no particular author. It's like an instruction book. So you just kind of fill in all the blanks with all of your information for you to give to your heirs.
That's a great idea.
Uh, the
Day
information
is
is
coming up though.
coming together to inform us all how to leave assets and how to find out what we're not aware of. Yeah, thank you so much for answering the question and providing the direction I will give. She's going to give HCAT a call. Okay. All right. All right. Well, thank y'all very much. I believe that's all we've got. I don't have any other questions that were emailed to me. And I don't see anything online. So, so we were talking about disaster preparedness and disaster assistance. We have our annual home improvement and um, home maintenance resource fair that's coming up on June the 27th. It's on a Saturday. It's going to be at the Houston, Texas YMCA. We'll have representatives there to talk about home improvement loans, how those processes work, being able to qualify for those disaster programs and things like that. How do you clear title and how to protect yourselves with, home maintenance tips and issues and things that can arise during a disaster, without a disaster, just, keeping up with the longevity of your home. We're going to have an appraiser that's going to actually be there to talk about different modifications and things that actually add value to your home or different improvements that actually add value to your home, which could potentially increase your property taxes as well. What you need to know about that when people are not thinking about all these different little things. People don't realize how one thing kind of leads into another, which is how you guys, Miss Mabel, ended up on this particular presentation because of deferred property taxes. When someone passes, what happens? They only have so many days to actually to pay for it, and pay for past property tax
Mhm.
bills and on and on and on. So all of our workshops and presentations and things that we're providing to the community are constantly evolving based on other things that come up that we didn't think about before, like instructions. Now we got
Right.
instructions. That's something now we need to think about. What's the steps? What do you need to do? What's the order of things to get things done? So maybe that could be something else that we plan down the line as well. And I know, are we interested or potentially thinking about also Ms. Mabel, our estate planning for business owners and the business personal property tax presentation in the fall too?
We did talk about that. Yeah. And finally that's starting to get attention and traction. as a result of what is it, Senate Bill 9 and some of the,
Mhm.
so yeah, it's time that we develop that and see who we can provide that additional information to. And it's also important for just regular taxpayers, property owners, and property taxpayers to kind of know about some of the things that have shaped the property tax code over the last several years. So, you know, there might be some interest there too.
Okay.
Uh,
All right. So be on the lookout for more things. Following the presentation, I will send out a link of the recording for this presentation, all of the different resources that were mentioned, and the different other legal services that are available to you guys. The appraisal districts and the tax office's website to where to go to look up those different forms and the different videos and things like that will also be included in the email that I send out to you. On the screen will pop up a short little survey. If you guys could just take a couple of minutes to give us a survey, we'd love to have your feedback. And if there are any workshops or anything like that that we're not currently offering that you all may be interested in, then please, let us know so that we'll know planning forward what to prepare, what to provide for you guys in the future. So, with that being said, no, you guys will be back, Miss Mabel, on Wednesday, the 24th
correct.
for the property taxes, exemptions and payment options. And then we have our reverse mortgage, home equity line of credit and mortgage foreclosure presentation that's going to be on February, Lord have mercy, on June the 25th, in addition to the home improvement fair for June the 27th. So be on the lookout for all of those uh,
And
workshops to come. Yes, ma'am.
also, Nia, I just wanted to mention if you can send me a copy of the financial planner's question, that's something we may be able to address at the workshop on the 24th.
Okay.
So because
Okay.
we'll actually have someone from our appraisal department on that call.
Okay. All right. Miss Tempest, I hope you heard that. Well, I'll make sure that Miss Mabel gets your question in addition to you reaching out to them directly. So we'll get that taken care of for you. All right. Um, I just saw something. Okay, she said she did. All right. All right. With that being said, Ms. Donna, Ms. Vicky, even though we didn't get to see your face today, thank you very much for being available to us. Ms. Lisa, Ms. Mabel, as usual, this entire partnership and the collaboration of the A Month of Service organizations, we wholeheartedly appreciate you all joining us today. We hope that you all did receive the information that you intended to receive. Please, once we share the video with you, to pay it forward, to share the information with your neighbors, your relatives, your other family members or whomever that will also find this information to be beneficial. So every other month we are here. So please feel free to come back if you have other questions or needed any additional information or just want to come see us in person somewhere in the fall, then look for us to come to a site near you. I'm not gonna know where yet, but a site near you. So you all have a wonderful remainder of your day. You all take care of yourselves, you stay safe, and we will see y'all next time.
Thank you, everybody.
Thank you.
Thank you.
Thank you, everyone. Have a good